Sign the retainer, Rachel. You're a lawyer. This is literally your job. Derek needs you. That's what family does. That was the voicemail my mother left me at 7:14 on a Tuesday morning. No good morning. No how are you? Just an instruction delivered in the flat, certain tone she reserved for grocery lists and court orders. 12 words that assumed my compliance the way gravity assumes you'll fall. I set my phone face down on the kitchen counter and poured my coffee. The mug was heavy ceramic, dark green, a gift I bought for myself the day I passed the bar. I had driven straight from the testing center to a kitchen supply store and paid $40 for it because I wanted something in my apartment that existed purely for me. No occasion. No favor owed. Just mine. I picked up the phone and listened to the message again. My brother Derek, 32 years old, had signed a commercial lease for a restaurant space in Buckhead. $68,000 over 2 years for a ghost kitchen concept he had described to the family at Thanksgiving as basically a guaranteed gold mine. He had used my name as the secondary guarantor on the lease without asking me. He had forged my signature on a legally binding contract. The business folded in 4 months. The landlord was now pursuing both names on the document for the full remaining balance. I was a contracts attorney. I read language like this for a living. I understood exactly what my name on that lease meant, exactly what exposure I was carrying, and exactly how my brother had put it there. I did not call my mother back. I opened my laptop instead. The lease document had been emailed to me the night before by the landlord's attorney, a standard notice of default with my name highlighted in yellow in the guarantor clause. I pulled it up and read it the way I read everything, not for the story it was trying to tell me, but for what it revealed without meaning to. The signature block at the bottom had my name printed beneath a cursive scrawl that was close enough to mine to pass a casual inspection. Derek had practiced it. That was the part that landed like a stone in still water. Not the forgery itself. The rehearsal of it. He hadn't made a panicked mistake. He had planned this. I opened a new document and started typing notes in the shorthand I used during depositions, fast and clinical, stripping the emotion out of every sentence until what remained was only fact. Fact, my name appears on a commercial lease I never reviewed. Fact, the signature is not mine. Fact, the forgery enabled a $68,000 financial obligation to attach to my credit, my bar license, my professional standing. Fact, my brother knew all of this and did it anyway. I saved the document, encrypted it, and uploaded it to my secure cloud drive. Then I went to the window and watched the parking lot below my building fill up with morning commuters and let myself remember how I had gotten here. 4 years ago, I was a second-year associate at a mid-size firm in Atlanta, working 60-hour weeks and sleeping on a futon in a studio apartment because I had put every dollar of my salary toward my law school loans. Derek had called me on a Friday night while I was reviewing a merger agreement. He had gotten into a dispute with a contractor who had done shoddy renovation work on the house he was renting. He needed a demand letter. Could I write one? It would take me 20 minutes, he said. I knew it would take 2 hours. I wrote it anyway. He sent me a thumbs-up emoji and never mentioned it again. 18 months after that, my mother called to say that Derek's first business, a clothing resale shop, had received a cease and desist from a brand claiming trademark infringement. She framed it the way she always framed requests for my labor, as a situation that had simply appeared, like weather, that happened to require legal expertise to resolve. Could I look at it? It wasn't a big deal. It was just paperwork. It was not just paperwork. It was a federal intellectual property dispute that I spent 3 weekends researching and drafting a response for. Derek's shop survived. He thanked me by putting a story on Instagram about his incredible legal team. I was the legal team. I was also not on the payroll. I was his sister. I stopped counting the hours somewhere around year 3. Lease reviews for his apartment. An employment dispute when he fired a part-time employee incorrectly. A partnership agreement for a food truck venture that dissolved after 6 weeks. Every call from my mother followed the same cadence. The setup, the minimization, the appeal to family, the assumption of yes, you're already a lawyer, Rachel. It's not like it costs you anything. That sentence. The breathtaking logic of it. As though my expertise was a natural resource that belonged to the family the way a river belongs to the land it runs through. As though the decade I had spent acquiring that knowledge, the debt, the exhaustion, the sacrificed weekends, the relationships I had let go thin and break because I did not have time had simply happened to me, ambient and costless, and now existed purely for their convenience. I turned away from the window and sat back down at my laptop. My phone buzzed. A text from my mother. Derek is very stressed. He just needs guidance. You know how he gets. I read it once. I set the phone down. I pulled up the Bar Association's Rules of Professional Conduct and read the section on conflicts of interest. Then I opened the state's criminal code and found the statute on forgery of a legal instrument. Then I found the section on fraudulent conveyance. I was building a map. Not of how to help my brother. A map of exactly what he had done and exactly how thoroughly documented it already was. Here's the thing about forging a contract attorney's signature on a commercial lease. It is an act of profound miscalculation. Most people, when they forge a family member's name on a document, are counting on that family member's loyalty to paper over the fraud. They are counting on shame, on the desire to avoid conflict, on the cost-benefit math of family peace versus legal action. They are betting that the person they forged will quietly absorb the damage rather than turn it into a crime scene. What Derek had not considered was that I document everything. Every client call, every negotiation, every agreement. It is the discipline that separates contracts attorneys from everyone else. We do not trust memory. We trust records. I pulled up my calendar and searched backward. 6 months ago, Derek had mentioned the ghost kitchen idea at a Sunday dinner. I remembered because I had asked whether he had secured financing, and he had said he was working on it. I had made a note in my phone at the table, the way I always do, a brief entry that read Derek Ghost Kitchen Concept, Buckhead, no financing confirmed as of this date. I had not known then why I was writing it down. Habit. The same habit that had made me photograph the demand letter the moment it arrived, timestamp and all. I had never been added to that lease. I had never been consulted. I had never agreed to guarantee anything. And I could prove it. My mother called at noon. I let it ring. She called again. At 12:15. At 12:30, she texted, "Rachel, this is urgent, please answer." At 1 o'clock, Derek texted directly, "Hey. I know this looks bad. Can we talk? Mom says you haven't responded to her. The landlord is not messing around, and I really need your help here. I would do the same for you." I read that last sentence twice. I would do the same for you. The sentence a person says when they have never once been asked to do anything for anyone. I typed back, "I hear you. Let me review the document fully and I'll call you tonight." This was not a lie, technically. I was going to review the document. I was reviewing it extensively. I was reviewing it in the way a surgeon reviews a body before an operation to find exactly where to cut. I needed Derek to believe I was considering helping him. I needed him comfortable, not cornered. A cornered person gets a lawyer, demands discovery, muddies the water. A comfortable person walks into the open voluntarily and keeps talking. I called him at 7 that evening. "Rachel, thank God." His voice had that particular texture it always got when he wanted something warm, slightly breathless, performing relief. "I've been so stressed. This whole thing is a nightmare. The landlord is completely unreasonable, and I made some mistakes with the business, okay, I'll own that, but this is not a $68,000 mistake situation. Walk me through the timeline," I said. I kept my voice neutral. Attorney voice. The voice I used when I needed someone to feel heard while I was actually listening for something else entirely. He talked for 22 minutes. He told me about the lease signing, about how the business had started strong and then the permits took longer than expected, about the landlord raising issues about noise and kitchen ventilation, about the partnership that fell through. He talked about the money he had already put in his savings, a loan from a friend. He talked about how unfair it was. He did not, in 22 minutes, mention my name on the lease. "Derek," I said. "The guarantor clause." Silence. "Walk me through that decision." More silence. Then, "I was going to tell you. The signing date came up fast, and I knew you'd have questions, and I thought if I could just get the business launched and profitable first, it would never even matter. You'd never even know it was there." I wrote down exactly what he said, word for word, in the document on my other screen. "You thought I'd never know," I said. "It wasn't supposed to be a big deal. A guarantor is legally liable for the full amount of a lease obligation if the primary tenant defaults," I said. "That is the definition of a big deal." I know. Look, I'm sorry. I really am. But can you help me figure out how to get out of this? You're so good at this stuff. You know how to talk to landlords and their attorneys. You could negotiate this down, I know you could. Please, Rachel. This is my life here." There it was. The architecture of every ask he had ever made. "I'm sorry" delivered as a door opener, immediately followed by the request, because the apology was never really the point. The request was always the point. The apology was just the lockpick. "Let me think about it," I said. "I'll need to see everything. The original lease, all the correspondence, any texts or emails between you and the landlord or their attorneys." "Of course, yes, absolutely." "Thank you, Rachel. Seriously. I'll send everything tonight. Send it to my personal email, not my work address," I said. "And Derek, don't talk to anyone else about this. Not the landlord, not their attorney, not a friend. Just sit tight until I've reviewed everything." Got it. "You're the best. I mean it." He sent me 17 documents within the hour. I spent the next 2 days reading them the way I had been trained to read contested contracts, not for the stated intention but for the exposed truth. The lease itself was clean, standard commercial terms, my forged name in the guarantor block on page 11. The correspondence between Derek and the landlord was revelatory in a different way. In an email dated 8 weeks before the business closed, Derek had written, I want to be upfront that my guarantor may not have full visibility into the current operational situation. It was a sentence so specific in its evasion that I read it 4 times. May not have full visibility. The precise language of someone who knows a document contains a name that doesn't belong there and is trying to get ahead of it without admitting to it. I added it to my file. On the 3rd day, I called Derek back. Okay, I said. I think there's a path here, but it's going to require you to come in and meet with me in person, and I need you to bring every original document you have, the lease copy, the business registration, your financial statements. Everything. Seriously? In person? This is too complex to handle over the phone. And if we're going to dispute the landlord's claim, I need a complete picture. He agreed. We scheduled it for Saturday morning at my apartment. I told him to tell our mother it was a working session and that I needed him focused, not distracted by a family audience. He arrived at 10. He was wearing a button-down he had clearly ironed that morning, carrying a manila folder that looked organized for the first time in his life. He wanted to look like someone taking responsibility. He was performing competence for me the way he had once performed potential for our mother. I made coffee. I set the folder in the middle of the table between us. Before we start, I said, I need you to do something for me. Sure, yeah. I need you to write down, in your own handwriting, your account of how the guarantor line got filled in on the lease. He looked at the paper I slid toward him. A single blank sheet. Just your version of events. What happened? In your words. Is this for the case? It's so I have an accurate record, I said. Which was entirely true. He wrote for about 4 minutes. His handwriting was messy and fast. He used the word miscommunication twice and the phrase I assumed she understood once. He wrote that he had filled in my name because he believed, based on past conversations, that I would have agreed if he had asked. He did not write that he had forged my signature. He did not need to. He had just written, in his own hand, that he had used my name without asking. I took the paper. I thanked him. I told him I needed to use the restroom and would be right back. I walked to my home office, photographed the paper, uploaded it to my secure drive, and added it to the file that now contained his text messages, his voicemails, the email with the phrase may not have full visibility, my calendar note from 6 months ago, and the time-stamped photos of the original demand letter. When I came back, I poured us both more coffee and we spent 2 hours going through the documents together. I asked questions. I took notes. I nodded at appropriate intervals. I said things like that's helpful context and let me think about how to approach that. Derek visibly relaxed over the course of the morning. By noon he was leaning back in his chair, laughing a little, talking about the restaurant concept he wanted to try next once this was all sorted out. He thought I was his lawyer. I was building a case file. After he left, I sat in my kitchen for a while with my second mug of coffee and thought about the years of Sunday dinners and phone calls and documents I had reviewed and letters I had written and hours I had given. I thought about the futon in the studio apartment and the loans I had paid off a year later than I should have because I had spent weekends working for free. I thought about the way my mother said you're already a lawyer as if expertise was something that happened to a person rather than something they built through sacrifice. I thought about Derek writing, I assumed she understood on a piece of paper that was now in my secure cloud. Assets, I thought, don't protect themselves automatically. You have to structure the protection. The following Monday, I called the landlord's attorney. I introduced myself, I confirmed I was a contracts attorney, and I told him I would be responding to the default notice in a personal capacity regarding the guarantor clause. We look forward to your response, he said, in the clipped way that attorneys say things when they expect the response to be a settlement offer. I want to make sure you have all relevant information before we proceed, I said. Because what I'm going to send you is not a settlement offer. I'm going to send you a certified forensic comparison of the signature in your guarantor clause alongside my actual signature specimens, accompanied by a sworn declaration that I never reviewed, negotiated, or executed this lease in any capacity. A pause. I'm also going to include documented evidence that the individual who placed my name on this document did so without my knowledge, and that this constitutes forgery of a legal instrument under Georgia Code Section 1691, which is a felony. I will be copying the Atlanta Police Department's Financial Crimes Unit and the State Bar of Georgia on all correspondence, as the conduct at issue intersects with the unauthorized practice of law and fraud upon a court should any litigation proceed. Another pause, longer this time. Miss, I want to be very clear, I said, that I am not a party to this dispute. I am a victim of it. And I have documentation going back 6 months that establishes my complete non-involvement in this transaction. If your client proceeds to name me in any litigation, I will counterclaim against both your client and the primary lessee for damages, attorney's fees, and the full cost of clearing any adverse marks this fraudulent document has created on my credit history. There was a silence that had a specific quality to it, the quality of an attorney recalculating. I'll need to confer with my client, he said. Of course, I said. I'll give you until Thursday. I sent the packet the same afternoon. 23 pages. The forensic analysis I had commissioned through a handwriting expert I had used on a previous case. The sworn declaration. The timeline documentation. Derek's own email with the phrase may not have full visibility. His handwritten statement from Saturday. The calendar note from 6 months prior. I did not include everything I had. I never include everything in the first filing. You keep reserves. You never show your full hand until the hand is the only thing left. I texted my mother that evening. I've responded to the landlord's attorney. I've also referred the matter to APD's Financial Crimes Unit. I wanted you to hear it from me first. My phone lit up within 60 seconds. She was calling. I let it go to voicemail. She called 3 more times that night and twice the next morning. Derek called 4 times. On the second morning, Derek sent a text that read, "Rachel, what did you do? They called me. The police called me. You need to fix this. You're my sister. I thought you were helping me." I read it. I thought about every version of that sentence I had absorbed over the years, dressed in different words but always the same request: make this okay for me. Take the weight. Use yourself up so I don't have to feel the consequence. I typed back, I am helping you. I'm helping you understand what happens when you make decisions that have real consequences. I hit send. Then I blocked his number. I blocked my mother's the same afternoon, after the voicemail in which she told me I had destroyed the family and that Derek was just a little lost and that I of all people should understand that mistakes happen. I had listened to the whole message sitting at my kitchen table, and when it ended I felt something I had not expected to feel. Not anger. Not satisfaction. Quiet. The specific quiet of a person who has finally put down something very heavy. The landlord's attorney called Thursday morning. His client was withdrawing the claim against me entirely and would be amending the default notice to reflect only the primary lessee. There would be no further contact from their office. I thanked him and ended the call. I forwarded the conversation to my personal file, noted the date, and archived it. Then I opened the APD case reference number I had been assigned and sent the Financial Crimes Unit an updated status note with the packet attached for their records. The detective assigned to the case called me the following week. She had reviewed the documentation. She had questions about the email with the phrase may not have full visibility specifically, whether I had additional context for it. I explained. She took notes. She said the evidence was thorough and that they would be following up directly with Derek. She said this in the careful neutral tone of law enforcement, which meant nothing official yet, but it meant the file was open. And an open file, in my experience, rarely stays quiet. I took a Friday afternoon off for the first time in 3 years. I sat on my balcony with a glass of iced coffee and a novel I had bought 8 months ago and never opened. The Atlanta afternoon was warm and still. Traffic moved below me in its ordinary way. The building across the street had a window box of impatiens that had just started to bloom. I thought about how many hours of that 3 years I had given away to demand letters, to cease and desist responses, to emergency weekend calls, to the quiet accumulation of favors that had accrued on my end of a ledger no one else kept. I thought about what I might have done with those hours. What I had not written. Where I had not traveled. What I had not let myself want because wanting things for myself had always felt secondary to keeping the family functional. My phone buzzed. A number I didn't recognize. I answered because I always answer unknown numbers. Force of habit. It was a recruiter. She was reaching out about an in-house general counsel position at a tech startup in Austin. Fully remote for the first year, then the option to relocate. She had gotten my name from a colleague and thought I might be worth a conversation. I had a contract of my own that I had let stay unsigned on my desk for 2 months. A solo practice partnership offer, 2 other attorneys I respected, flexible hours, the ability to choose my own clients. I had been too busy managing other people's crises to decide what I actually wanted for my own life. I looked out at the impatiens across the street. Tell me more, I said. I signed the partnership agreement the following Monday. I called the recruiter back Tuesday and said I'd take the informational call. I started keeping my own legal hours, billing myself for my own time, the way I had always billed clients, because that was the only honest accounting if I was worth $180 an hour to a stranger. I was worth the same to myself. The detective called again 6 weeks later. She had enough to proceed. Derek had been charged with forgery in the first degree and fraudulent use of another's name, both felony counts under Georgia statute. Our mother had called me twice after the charges were filed. I let both go to voicemail. In the second message, she said she hoped I was proud of myself. I listened to it standing in my kitchen on a Wednesday evening. The green mug was in my hand, still warm. I had just made dinner for myself, something elaborate that took an hour, something I made because I wanted to, because I had the time now. I deleted the voicemail. Not out of bitterness. Not out of satisfaction. Exactly. Out of the same impulse that makes you close a browser tab when the article has finished loading. The subject was complete, and there was nothing more to read. I had spent years believing that being useful to my family was the same as being loved by them. I had let that belief be expensive. I had let it cost me hours and money and opportunities that did not come back when I asked for them. I had structured my entire sense of being a good person around my willingness to absorb their consequences. That is not love. That is liability. And a good contracts attorney knows the difference between a relationship and an obligation, knows when to renegotiate, and knows when the terms have become so unfavorable that the only rational move is to let the contract expire. I finished my coffee. I rinsed the mug. I set it in the drying rack. The night outside my window was clear and warm. Somewhere across the city, my brother was figuring out what accountability felt like without me there to cushion it. That was, I had come to understand, not my problem to solve. It was the only real gift I could give him, the same one I had finally given myself. The chance to find out what you're capable of when no one is carrying you anymore. I picked up the novel I had started on the balcony. I sat down. I found my page. I kept reading.